I'm the senior staff attorney in the children's program. And I have presented to the CASAs of the 17th Judicial couple years in a row in the 2018 and 2019. So I'm happy to be back and talking to you all. I think today what we'll do is we'll review kind of who my organization is, Rocky Mountain Immigrant Advocacy Network, and what we can offer immigrants and you all as service providers. And then sort of leading into pathways towards lawful immigration status for victims of crime and their families, which is primarily who we serve. We can also talk about sort of why children come here, what types of, what buckets of status each child might fall in, and kind of where you might encounter them. And then, of course, we'll have time for questions, any questions that you have. And again, I'll just repeat that if you have a very case-specific question, feel free to email me. My email is at the end of the presentation, but if we want to talk about broad concepts, that's totally fine. We can talk about kind of legal information for those types of cases. Again, none of my this is all legal information. It's not going to constitute legal advice if we're talking about a specific case. Okay, so who is Remain? So we started off as a small organization for detained immigrants at the GeoIce detention facility in Aurora. So there's many of you probably know this, there's a detention center in Aurora that houses adults who have either been picked up in the United States or being transferred from a border situation and being held in Colorado. They can also be transferred from an internal apprehension from across the country. And the detention program started as a small group of lawyers who realized that there were a number of people in this detention facility who couldn't afford lawyers, and therefore were not being given sufficient information about what their rights were, what types of relief might be available to them, and any information about how they might be able to move forward with a case, right? Fight an asylum case or present a different defense to their removal. And so they started representing individuals, but also the key part of one of the key parts of our detention program is the legal orientation program, which is essentially a Know Your Rights campaign, where where a lawyer from our detention program every day is presenting on people's rights, what they and what type of relief might be available to them. And that has continued through the pandemic, just virtually, as opposed to actually being physically in the detention center. So then, our children's program kind of arose out of across the state. There were juveniles and their parents contacting Remain saying, okay, my child isn't detained in the detention center in Aurora, right? They're not an adult, but they are detained in juvenile detention, and they have no access to legal representation or information about what their rights are as an undocumented child. And so one lawyer started the children's program on a fellowship, basically, to provide services to children detained in Colorado in their juvenile detention, in Colorado's juvenile services department. And out of that fellowship grew our children's program, which we now have, I think it's 6 lawyers and 2 paralegals, and we serve a whole range of immigrant youth, primarily who have suffered abuse, abandonment, or neglect, trafficking, or a crime. We also expanded in December 2019 with the arrival of a shelter in Colorado, which is essentially, it's not a detention center, it's not a jail, right? The children are being held at Devereaux in Westminster, but it is a shelter with the Office of Refugee Resettlement of young boys who are arriving at the border as unaccompanied alien children. So we have a whole team that works with those boys, providing Know Your Rights presentations and representation until they are released and oftentimes transferred to another state because they're being sent to where their family members are. Additionally, at our organization, we have a social service project, which is a team of 3 social workers who work primarily with the detention program, but also with the children's program. Their main, their initial goal was to support those detained for months on end at the Aurora detention facility. Since many of the individuals who are held at the detention facility, they're not serving criminal sentences. They're there seeking asylum or presenting a case as to why they shouldn't be deported in conditions that in many situations are more restrictive than a criminal sentence would prove to be. And so individuals' mental health has suffered. And so our social workers are there to support them and guide them through basically presenting their case. And then we have we call it a human trafficking project. Obviously, we're not trafficking people ourselves, but it's our anti-human trafficking project that's run by one attorney who's an expert in human trafficking and defending those who have been victims of human trafficking across the state of Colorado. So that's kind of our program in a nutshell. The only addition I would make is that our children's program, when the courts are up and running, there is an attorney from the children's program at any immigration proceedings at the Denver Immigration Court where a child is on the docket or a family is on the docket. So we provide Know Your Rights presentations. We assist them with any change of address forms or any forms that they're required to complete at that time. And then we provide them information as to how they can get a free consultation with our organization. So that leads me to kind of what the children's program provides in terms of services and how we might be able to help immigrant children and families. So we provide free consultations with children and their families. We're currently on an intake freeze just to kind of make sure that we've got capacity to take on new cases. We're hoping to reopen on April 1st. We do have exceptions to that. Those exceptions are DACA cases because with the, and I'll talk more about this later in the presentation, but with the reinstatement of DACA, we want to make sure that all DACA eligible children and adults are either renewing their DACA status or applying for an initial DACA approval if they weren't able to prior to the Trump administration. So we consider those to be emergency cases. And there's actually on our website, we have a kind of autofill questionnaire that a DACA eligible individual can complete, and then they'll be contacted with respect to whether or not we'll take their case. There are very limited circumstances in which we won't take a DACA case, but in most cases we will be taking or referring to a pro bono attorney. The other exception is something we classify as an emergency case, which is a little bit difficult to kind of determine what's an emergency, but usually it's if someone is in active removal proceedings and they have been given a hearing date that is upcoming, or are facing some other form of removal action, or might age out of some form of relief. Additionally, as I said, we provide representation and Know Your Rights presentations for children in the custody of the Office of Refugee Resettlement in Colorado, which are boys aged 12 to 18 at the Devereaux facility in Westminster. So we have one attorney and one paralegal that are specifically designated to providing services to those young men. We provide representation on immigration cases before United States Citizenship and Immigration Services and the Denver Immigration Court for children and their families. Unfortunately, we're not able to provide representation to adults who do not have children or single adults on the docket of the Denver Immigration Court, but we absolutely are able to provide a list of resources for those individuals so that they know where they might be able to receive services at low cost or for free. We also have a robust pro bono referral program. So, we're only 6 lawyers. There's a limited number of cases that we can take at any given time. And so the way that we are able to help many more children is by soliciting the assistance of lawyers across the state of Colorado, tax lawyers, corporate lawyers, public defenders who are interested in immigration law and interested in helping children and their families. And we mentor them through a case. So we are able to provide them with templates and case memos. And then we're available for any questions or any assistance along the way. Then we provide Know Your Rights presentations for children and their families before the Denver Immigration Court. So like I said, when the immigration court is in session, which right now the immigration court is open. However, they are not setting individuals who do not have attorneys for cases right now due to COVID protocols. So once those hearings open up, we will be back at the court giving Know Your Rights presentations and assisting there. And we advise the Office of the Child's Representatives on cases in dependency and neglect and in JD proceedings. So if there's a child who is in a juvenile delinquency proceeding and needs advice on what the immigration consequence might be to any given plea deal, we have a contract with the Office of Child's Representative to have guardians ad litem reach out to us to provide advice on whether or not a plea deal is safe for any immigration case. And it also allows us to encounter children who might not know that they are eligible for relief, right? That this is the first time they've had interaction with any kind of professional, and for the first time, someone might be able to help them assess whether or not they might be eligible for immigration relief. Same within a dependency and neglect. So that's kind of, in a nutshell, what our children's program, what the services are that we provide. We also have, small advocacy roles. Our lawyers, specifically our managing attorney, has been instrumental in some legislation that has gone to the Colorado legislature on special immigrant juvenile status, which I will talk about when I speak to relief, and U visa certifications, which is a required certification from law enforcement in order to apply for a U visa as a victim of crime. Are there any questions about our services?
I'm not seeing any in the chat.
In the chat, okay.
Yeah.
I figured I'd just give a pause if someone wanted to put a question in the chat. Okay, so now I'm going to sort of talk about kind of where we see children and how we might determine that a child's undocumented. So obviously what's in the forefront of the news at the moment is that there is what's being deemed a surge of unaccompanied children at the border entering the United States. And so an unaccompanied child is a very specific definition under federal law, and that is a child who arrives to the United States and is under the age of 18 and has arrived without a legal guardian who is able or willing to care for that child. So what we're talking about is children who arrive at the border and are basically not here with a parent, right? There's no legal custody over that child with either that child has arrived at the border with another adult, but that adult does not have any legal custody arrangement over that child, or the child has arrived at the border and is there with a group of other children or has come by themselves. Where are these children coming from? They're primarily coming from the Northern Triangle, right? So Honduras, Guatemala, El Salvador, and of course, Mexico. But we are seeing kids coming from India, Brazil, and other parts of the world through the southern border. And that's basically because it's much easier, like it's hard to get a visa to come to the United States. If you're coming from India, for example, you're not going to be able to obtain a visa and come to the United States, but you can travel from India to Honduras, Guatemala, or Mexico, and then present yourself at the point of entry and request asylum or be deemed an unaccompanied child. So a lot of these children are basically going on months and months long journeys from other parts of the world and traveling up through South America and presenting themselves at the border.
Emily, we did have a quick question. What percentage of immigrants are unaccompanied children?
What percentage of immigrants? That's a very good question. I'm not sure what the percentage is, but I would say that certainly in the last few years, there has been a significant increase in unaccompanied children. It used to be that, the people who were coming to the United States would be single men who were coming to work and support their families or escaping sort of more civil violence and gang related violence. And so they were leaving because there were either because there were fewer acts of violence committed against families, or just because it was not deemed safe enough for families to be traveling. But as conditions deteriorated in the region, right, you've got extreme poverty, you've got increased gang violence. Most recently, there were natural disasters in Honduras back to back that have meant that essentially, infrastructure has been destroyed. As those factors became more and more intense, children were being sent as a way to protect them, right? There was no parent is going to say, here, go travel through Mexico through this very dangerous trip just because I don't want you here, right? It is basically, we're on this crashing train and I have two options. You can either crash with me or I can throw you out the window and hopefully you'll survive. And sending them on this journey with either other children or with another adult is a way to protect their children. Additionally, we've seen over the past few years, more female children coming, and generally more females in groups of women and children, basically fleeing domestic violence. And that, I think, has come about as more information has gotten to Central America about the fact that while our system, as a former domestic violence attorney, like our system is by no means perfect in the United States to protect survivors of domestic violence, but it is certainly better than those systems in the Northern Triangle. And so there was information about the fact that if you can make it to the United States, then there are systems in place to protect you from systematic violence against women. For example, for a long time, Guatemala had the highest rates of femicide in the world, and it was done with impunity. And so there was basically an influx of women and children who were escaping domestic and familial violence. But I would say there are still a good proportion of people who are coming as family units, and whether that's intact nuclear families, so whether that's a father, a mother, and their children, or a mother and children, or even we're seeing fathers and children, especially fathers bringing their preteen sons as a way to protect them from gang recruitment, right? They say, okay, well, they've been threatened once or twice now, and at this point, I either have to give him up to the gang or allow him to be killed, or we're going to go to the United States. And so they make the choice to make the trip here to protect their sons from gang recruitment. Any other questions on unaccompanied children? Okay, so that's a good group of kids that we see in Colorado. And I think the last statistic I heard, which I think came out of 2019, was that there were 600 unaccompanied children that were released into Colorado in 2019. And when I say released into Colorado, when children arrive at the border, and this has been in the news recently because the rule has been violated most recently, a child needs to be transferred from the custody of immigration at the border to the Office of Refugee Resettlement, which is modeled in a child welfare model, within 72 hours. So a child is not supposed to spend more than 72 hours in a border detention facility. Right now, I think that the statistic is 107 hours is how long children are being held in immigration detention facilities. But then they're transferred to the Office of Refugee Resettlement, which is a system of shelters across the United States, shelters and group homes, and in some situations, foster care arrangements. And while they're in the custody of the Office of Refugee Resettlement, social workers and caseworkers are tasked with vetting and finding relatives in the United States, relatives or family friends in the United States who are willing to take custody of those children. And I think, that's how, well, I know that that's how a lot of unaccompanied children end up in Colorado, because they're being released to parents or family members in Colorado. Most recently, one change that we've seen in the change of administration is under the Trump administration, we saw a drop in the number of sponsors coming forward to take responsibility for children, because there was an agreement between the Office of Refugee Resettlement and the Department of Homeland Security to share information. So if a sponsor came forward and was undocumented, that information was being shared with the Department of Homeland Security, and there were actually enforcement actions taken against sponsors who came forward to support children. That agreement was just recently canceled last week. So that agreement is no longer in effect. And so sponsors can come forward knowing that their information will not automatically be shared with the Department of Homeland Security. And so they are not as much at risk for an enforcement action. I think that does not mean that information about a criminal who came forward with a serious criminal history to claim a child wouldn't have an enforcement action taken against them. It just means that those who are undocumented are living productive lives here in the United States, have not committed any crimes. Their sole immigration violation is to have entered the United States without permission. They can come forward and take care of a child, right? I think we can agree that the best outcome for a child is not to be living in a group home situation, but rather to be placed with family members or family friends, people that they know, or at least are from their same culture and can feel comfortable. And so to ensure that people feel safe coming forward to claim children and to support them is sort of I think is a good goal. Okay, so that's unaccompanied children. We also see, children who clearly came with their family a long time ago, right? DACA eligible children who came as babies and are now in their teens or early 20s. And basically the only country they've ever known is the United States. They might as well be your average American kid. So we see a number of those children. And then there are family units that, as I spoke to earlier, are escaping violence, be it familial violence or gang violence, and they've come as a family unit. And then we also do intakes with families where the children themselves are documented. They are United States citizens. They were born here, but their parents are undocumented. And our organization takes the position, our program takes the position that assisting the parents is assisting the child, right? Nobody wants the children to be living in a situation where the family is unstable due to the parents' undocumented status. And if there's a way to help those parents, we are also helping the children. Yeah.
Emily, we do have a question. Is there a way, and I would say, how are the sponsors notified that the rules have changed recently?
Well, so I think there's certainly been a media campaign that has started within Spanish language media to get that information out. People have come to us to ask us to help them navigate sending in their information about being, to be a sponsor. And so we've gotten that question historically. And so now we're able to answer, no, you should be fine. Like, we can't promise anything, right? But this agreement is no longer in effect. But I think that's the main thing. And then also, what happens is a social worker is basically going to ask the child, who should we contact? Who should we call? And if the child has phone numbers, they're going to call those phone numbers and contact those individuals. And in those contacts, my understanding is that they will be reassuring people that they will not be sharing their information, unlike previously where their statement would essentially be like, your information is now going in the system. That's up to you. Do you still want to proceed? I think that the sort of explanation has changed when they're calling families.
And then Ashley asked, can anyone be a sponsor, or is it just a relative?
So there's a tiered system for sponsors. And preference obviously goes to a parent. And then there's the second preference is going to be a blood relative, so an aunt, an uncle, a grandparent. Then there's going to be a third preference, which is going to be family friends, so people who can be connected to the family. And then the fourth preference would be to an unrelated, unknown sponsor. And it's very, very hard for someone who is not related and who has no connection to a child to become a sponsor for that child. It's not impossible, but it's very difficult. A number of us looked into it when there were surges to doing it, and it is quite difficult. You can look at the, and I can, if we take a break, I can, at some point, I can look for the link, or I can share it with you, Becca, and you can distribute it. But there's a link to all the requirements for applying to be a sponsor. I can send that. It's with the Office of Refugee Resettlement.
Thank you.
Mm-hmm. Okay, so those are sort of the general categories of children that we encounter in Colorado, and kind of the types of family units that we end up representing. Now I'm going to talk about common pathways toward immigration status. These are the sort of common pathways that we see, that the common pathways that we're able to assist with. Okay, so DACA has been in the news obviously recently because of its reinstatement. Deferred Action for Childhood Arrivals was an executive order signed on June 15th of 2012 by President Obama. It was rescinded by the Trump administration on September 5th, 2017, and all applications halted at that point. Then through a series of federal litigation, we have ultimately arrived at the federal courts ordering USCIS to continue accepting both renewal applications, and they additionally have ordered them to reinstate initial applications. So those are both categories of applications that we are assisting children with. To qualify for an initial application, the following must be true. You must be at least 15 years old and have been under 31 years old as of June 15th, 2012. Must have arrived to the US under the age of 16, have continuously resided in the US since June 15th, 2007, be present in the US on June 15th, or have been present in the US on June 15th, 2012, are currently in school, have graduated from high school, have a GED, or are honorably discharged from the armed forces, and then have not been convicted of certain criminal offenses or pose a threat to public safety or national security. So the certain criminal offenses are essentially not to have committed a significant misdemeanor, which generally means a crime against the person, or obviously felonies or anything more serious than a misdemeanor. Renewals are essentially just continue. Obviously, they would have qualified under these requirements, and then they just have to have continued their physical presence in the United States and not have committed an additional or any criminal offense. Does anyone have any questions about DACA? Again, DACA is an exception to our consultation freeze because we really want people applying for a renewal of their DACA status, or if they were never able to apply previously, to come forward and file an initial DACA application. We are hopeful that there will be some additional protection for DACA holders, or a pathway to lawful permanent residence or citizenship in the future. But obviously that time will tell as to whether we get immigration reform. Okay. Another form of relief that we deal with regularly, and some of you may have actually come across, is special immigrant juvenile status. So this is a pathway to permanent residence only for a child under the age of 21 and unmarried. So the child must be under 21 and unmarried. They must be under the jurisdiction of a juvenile court. And a juvenile court for these purposes is defined as a court having the authority to make decisions about the care and placement of juveniles. So that includes cases in probate for guardianship proceedings, cases in domestic relations, custody cases as part of a divorce action, or an independent custody action under an allocation of parental responsibilities. Clearly, dependency and neglect proceedings qualify. Juvenile delinquency proceedings, since the judge does have the authority to make decisions about the care and custody of that child, and then a proceeding for adoption. The court must make findings that the child cannot reunite with one or both parents due to parental abuse, abandonment, or neglect. And they must make the finding that it is not in the child's best interest to return to their country of origin. It used to be that special immigrant juvenile status was only for children who have been abused, abandoned, or neglected by both of their parents, but the statute was revised to allow for special immigrant juvenile status where there is only one parental offender. It is a two-step process. The first step is the state court involvement. And here's where many of you may come in, or many of you may have interacted with special immigrant juvenile status, because this is where the state court must take jurisdiction over the child, either by petition of a proposed guardian parent or the Department of Human Services, so it's a petition by either the proposed guardian. So in a guardianship situation, it's going to be either a family member or a friend of the family who comes forward and says, I want to take guardianship over this child, or a parent is petitioning the court for custody over the child, or Human Services has obviously filed a petition in dependency neglect. Yes.
Quick question, because we do actually use this in training. Can an undocumented family serve as that guardian?
Yes.
Okay. I've been giving the wrong information this whole time.
There's no reason why someone who does not have status in the United States should be denied the right to be a guardian over a child.
But they cannot serve as a foster parent, correct?
You know, I don't think that that's true. I think actually they can serve as a foster parent. I think that I mean, I am by no means an expert as to the rules as to who can become a foster parent, but I know that especially where there's already a kinship relationship, I have seen children placed officially by the court with that family member.
Great, thank you.
Mm-hmm. It may be that it may be that ideally, if someone were going to apply to be a foster parent in the state, right, just because that's a goal of theirs, not because there's a specific child that they want to foster, it may be that they are precluded from doing so. But I don't believe that someone's status will preclude them from taking custody of a child if they have a pre-existing relationship to that child. It may be that they can't receive all the services available to foster families, right? There may be some rules as to certainly federally funded resources that are not available to those who are undocumented, but I don't think that there's a blanket rule. So a judge must make the requisite findings and then issue what's called the predicate order. So it's an order that basically has all of those findings, that the child is under the age of 21, that they are unmarried, that they are under the jurisdiction of the court and have been placed in the custody of someone by the court, that they were abused, abandoned, or neglected by one or both of their parents, and that it is not in their best interest to return to their home country. Once we have that order from the state court, then we can apply with immigration for the visa. And the child has to file what's called the I-360 petition for special immigrant juvenile status. And in certain situations, they can also do the next step concurrently with that petition, which is to apply for the green card. But in many situations, because there are caps on the number of visas available each year, certainly to the north, from the Northern Triangle, there's a waiting period. And so they can have the I-360 approved. By statute, is supposed to be adjudicated within 180 days. Once that visa is approved, then they have a waiting period for when their priority date is current. And that priority date is the date on which their application was filed. And that's how they have a wait list essentially for whether or not a visa is available in order to apply for the green card. And right now in the Northern Triangle, it's taking about, for children from the Northern Triangle, it's taking about 4 years to process the green card application. So while they might have the petition approved within 6 months for their visa, they're going to wait an additional 3.5 years, perhaps even more, to receive their green card because of these caps in the number of visas that are available each year. However, a child from a country like Haiti, for example, where they don't fulfill the cap each year, is going to be able to apply generally for the visa and their green card at the same time, and that should be processed within, 6 months to 8 months. They might grant the visa and then process the green card application a couple months later. Are there any questions about special immigrant juvenile status?
Well, I had a quick question. Does sending your child on this trek count as abandonment?
So we don't take the position that it does. What we generally, I would say the way we assess whether or not it would end up being abandonment is if that child no longer has any contact with a parent and that parent makes no effort to provide for that child, have contact with that child, provide for the child's emotional needs, that kind of thing. And so I would say that generally you're not going to use that as a basis for abandonment. However, under Colorado law, neglect does not have to be a volitional act, right? You don't have to intentionally neglect your child to be a neglectful parent. And so one of the areas that we find very difficult, but we think that it's in the best interest of the child, is to assess what was available to the child in home country, right? Were they going to school before they came to the United States? Or was it so expensive that their parents couldn't afford it? Or was it that the family didn't have enough money, and so they had to have the children also work in the fields with machetes and, potentially risking serious injury? Did the child have enough food? Did the child eat 3 times a day? Or were they only eating 2 times a day or 1 time a day, or once a day? Did the child have enough clothing, right? Many children report to us that they had 1 set of clothing and 1 pair of shoes for the entire year, and that even if their feet grew, that was it, right? That was all that was available. These factors can satisfy neglect under Colorado law, and so would make a child eligible for special immigrant juvenile status. And so that might be factored into why a parent might have sent their children to the United States, right? For right now, reports out of Guatemala are that children are dying of starvation in frightening numbers. And so, it's not that that Guatemalan parents are uncaring and they don't want to provide for their children, right? They just can't. And so they are in effect neglectful parents by virtue of their situation. Believe me, we're very uncomfortable with poverty as neglect as an argument. We don't want to be seen as punishing parents for their situations, especially when it's poverty. But in the end, it protects the child, right? It protects the child from returning to that poverty situation, from returning to a life that more than likely would result in their death. Did that bring up any other questions?
Yeah, there was another one. Is there any potential downside to an unsuccessful application? I think what he's asking is if they apply, is there any sort of punitive for being put on the radar, right?
Right. So this is sort of a nuanced question, as is most things in the law, right? My favorite phrase is "it depends," right? Which is terrible.
I hear that from me a lot.
Right? Well, it depends. So under the Trump administration, there was specifically a memo that said that where an application had been denied, USCIS was specifically directed to then place that individual in removal proceedings. That memo has been rescinded. And so there is no longer this directive to place someone in removal proceedings if their application is denied. And I would say, even under the Trump administration, I think that there were certainly times where officers forgot to file the notice to appear, right? In cases of special immigrant juvenile status, right? Because what we're talking about is children applying for status based on being abused, abandoned, or neglected. And there are certainly officers out there that that take their job extremely seriously and believe that they want to protect the United States from an influx of immigrants. But I think that there are some very good officers who are doing it to try and protect people, right, and try to help people. And so they forgot to file that notice to appear. I do think that under this administration and in previous administrations, regardless of political affiliation, something like special immigrant juvenile status and many of the forms of relief that we'll talk about today are considered humanitarian relief, and so are not, if they're denied, they're not going to place them in removal proceedings, right? They have no interest in taking action against them. They might find that they aren't statutorily eligible, but they have no interest in going after these people. So I think certainly now with that memo having been rescinded, there is very little concern about consequence. I would say even in cases of juvenile delinquency, so there are cases, I have cases of young men who have pretty serious criminal histories. They're all juvenile delinquency proceedings, but they're pretty serious. They're drug related, or a weapon is involved. And I would say previously, I very specifically held off until they were about to age out before I would apply for the visa itself. But generally, I would say that we may still make the decision to file for the visa portion, right, the I-360, because there's nothing discretionary about the visa petition, right? They are either statutorily eligible or they're not, right? And I'm not going to file a petition where someone's not statutorily eligible. There's also no fingerprinting attached to the visa petition. So they might, that's not to say that they can't do a name search or they can't try and contact local authorities if they have any suspicion that this individual has a serious criminal history, right? The order coming out of juvenile delinquency is going to tip them off to the fact that there was an arrest, but they're not going to have fingerprints done, and so an FBI background check is not going to be done. And so in many situations, especially nationally, in many jurisdictions, you can't actually access juvenile delinquency records without a fingerprint run. And so I would probably file that visa petition to just maintain their eligibility. But what gets sticky is the second part, the green card application, because that is highly discretionary. So it's in the officer's discretion as to whether that child is deserving of a green card. And so I would wait until a child with a criminal history might have developed positive equities, right? Children do stupid things, right? Teenagers specifically. That prefrontal cortex just isn't, it's not there. There's no impulse control. And so they do stupid things, which means that they can actually build a positive record after, being held accountable for that stupid mistake that they made. And so I will there are many cases where I will still apply for a green card, but generally they have to have built up a significant history of change. It's a very long-winded answer to your question, but I hope that answered it.
Thank you.
Mm-hmm. Any other questions on special immigrant juvenile status?
So far, so good.
Okay. Then we have the U visa for victims of serious crimes. So where someone is the victim of a qualifying crime, be it domestic violence, felonious assault, sexual abuse, there's a whole list of crimes that qualify a child for a U, or an adult. Generally, it's a crime against a person, or a violent crime. And generally it's a felony. The exception being sexual abuse and domestic violence generally they can be misdemeanors because they're considered serious enough crimes that even at the misdemeanor level, we want to qualify someone. They can be an indirect victim. So for example, a US citizen child victim who is so young that the parents really are the ones cooperating with the investigation. In that situation, the parent can be the indirect victim. We also have had cases where the child was the victim of homicide, right? The child was killed. And so then the parent becomes the indirect victim. The crime must have been reported to law enforcement. So, this is a little bit difficult in domestic violence situations, right? Because it's not always in the best interest of a victim to come forward in a domestic violence situation, especially if the crime that they're just going to be investigated for is a misdemeanor, and they're not going to go to, the consequence is not going to be particularly severe. It might just be in the best interest of that victim to smooth things over. And so even if there was a crime perpetrated, if it was never reported, that individual does not qualify for a U visa. And that's because cooperation with law enforcement is required. So some of the initial required evidence is a law enforcement certification, and that's where law enforcement, either the investigating police body, the DA's office, or in fact the judge, or in certain situations, Child Protective Services, someone authorized by that agency to sign these certifications has to sign, basically attesting to the fact that the individual was a victim. That does not mean that the crime has to have been prosecuted, or even that the individual ultimately was found guilty of that crime. They just have to attest to the fact that they believe that that victim was a victim of a crime, one of those enumerated crimes. So, there are many reasons why law enforcement doesn't proceed with an investigation, be it there weren't enough witnesses, be it there wasn't enough physical evidence, whether there was a problem in the investigation, whatever it is. Even if they don't forward their findings to the DA's office, they can still sign that law enforcement certification, as long as the victim, as long as they believe that the victim was the victim of a crime, that they are cooperating with law enforcement and would have been willing to testify against the perpetrator. They also must show that they suffered substantial physical or emotional harm as a result of the crime. And this is where advocates and professionals can really assist a family or a victim, because there's no rules as to how you show that, right? It's not that you have to show that you have hospital records or any kind of physical harm. Professionals who are working with victims can provide letters of support, right? Explaining why they know that this victim suffered physical or emotional harm as a result of the crime. And that's enough to show that harm and allow for the immigrant to qualify. So the U visa is a really important tool, and it was put in place, by Congress in order to address the fact that undocumented individuals were not coming forward to report crime, right? Because they were afraid that when they came forward to law enforcement, not only would they not be helped with their victimization, but that they would become subject to an enforcement action. And so this was a way to kind of reassure people that, if you come forward and you cooperate with law enforcement in investigating this crime, then we will help you be protected. Not only will we not take action against you, but we will help you get relief with immigration. And the U visa itself is a 4-year permit to stay in the United States with work permission, but then comes with the right after 3 years to apply for a green card based on that U visa status. So ultimately, it is a way to become a lawful permanent resident and then a United States citizen. I think that we've seen a dip in the number of people coming to us for U visas. I think it's a product of increased enforcement action, even against U visa applicants by the previous administration. And then also COVID, right? COVID has meant that people just are not going to law enforcement, or they're just not interacting with people. I think hopefully reassurance by the current administration that they have no interest in taking action against the majority of people who are here undocumented will mean that people feel safer coming forward. And as we come out the other side of this pandemic, hopefully people will be able to report crime and get relief from domestic violence situations. Any questions on the U visa? Nope.
None that are popping up.
Okay. A sort of related form of relief is the Violence Against Women Act protection. So in order to fully explain VAWA protection, I have to back up a little bit and talk about generally the familial immigration process. So generally, when a U.S. citizen or lawful permanent resident family member is applying for family members to come to the United States to join them in the United States, they are the ones who are in control of the petition. So the intending immigrant has no control over whether or not a petition gets filed. And so that in itself creates an inherent power disparity, right? So it's you end up with someone with status in the United States with all the control over the immigrant's ability to come to the United States or be protected in the United States. And Congress recognized that, especially in situations of domestic violence, this really was problematic, right? Because there were abusers using that as a way to control their victims, whether it was a way to control making or make them do something. So whether it was like, if you don't have sex with me, I won't put in your papers, or if you don't do things around the house the way I want them done. And I don't mean that as in like, decor. I mean, essentially servitude within a marriage. Or if you call the police, I won't petition for you, right? If you try and access law enforcement, I will not put in that petition to protect you from immigration. And so that Congress decided they wanted to put in place a form of relief that would protect victims from that power disparity and allow them to escape the situation. So it's a pathway to legal permanent residence for victims of domestic violence specifically. So they must be the spouse, parent, or child of an abusive US citizen or lawful permanent resident. So in this situation, unlike the U visa, where the immigration status of either the victim or the perpetrator is irrelevant, other than the fact that you're not going to apply for a U visa if you already have status. In this form of relief, the immigration status of the abuser is key, and the relationship to the victim is key, right? So again, in the U visa situation, you can not know your perpetrator, right? There were a number of undocumented individuals who were in the movie theater when it was shot up in Aurora. They received U visas based off of being the victim of felonious assault, based on that shooting. They had no relation to the perpetrator. In this situation, you must have that relationship to the perpetrator in order to qualify. However, it doesn't matter in this situation if the domestic violence was ever reported to law enforcement. It helps, right? I love it when I have a police report that I can file to show, that there was domestic violence, but it's not required. What they are required to show is proof of the abuser's immigration status, which obviously can be difficult if you're in an abusive relationship. It's not like you can walk up to your abuser and say, hey, do you have a copy of your birth certificate I could have? Like, you're not going to do that, right? Or where's your passport? I'd love to get a copy of it, right? But you can, if you don't have access to it, or if you aren't able to, like, depending on the state, you can access vital records if you are the individual's spouse. But if you don't have the ability to do that, that requirement can be put on immigration to determine. You have to show that there was a good faith marriage. So that doesn't mean, good faith marriage doesn't mean the sort of hallmark concept of marriage. It's not, oh, we're absolutely in love and the whole thing. It just means that it's not for immigration purposes. So it can be an arranged marriage, for example, because that is a valid form of marriage within certain cultures. You have to show joint residence at some point with the abuser. There's no time limit, right? So it can be as little as a few days, right? You can have situations where it's an arranged marriage. The married couple met in home country when they were introduced to each other by their family members. They've now come to the United States. They flew back to the United States. A few days into the marriage in the United States, he starts beating her. That's enough for VAWA. You have to show that there was battery or extreme cruelty. So physical abuse or other power and control, I'm sure you all have seen the power and control wheel. Any of those types of power and control um, uh, situations can be deemed extreme cruelty. And in fact, threats of immigration action in itself have been deemed extreme cruelty under immigration law. So just the act of saying, if you don't do what I want you to do, I'm not going to petition for you, is deemed extreme cruelty. Because Congress understood the extreme power that someone with status has over someone who is trying to be here in the United States. And then you must show that you're a person of good moral character. So this form of relief essentially allows the victim to petition in the way that the person with status would have done traditionally. So it allows them to step into the shoes of the petitioner. And it's absolutely confidential. No one can access these applications without very specific authority. So even attorneys, if they lost our notice of entry of appearance, it's very frustrating because we can't actually follow up on the petition or get information. And it is highly, highly, highly confidential for this reason, right? Because the idea is that the victim is allowed to petition in for their own status, and they are alleging domestic violence. Any questions about VAWA? I very specifically use the example of marriage because that's often where we see it, right, within the confines of a marriage. But that doesn't mean that a child couldn't be the applicant. So I'll give you an example of a VAWA situation. So let's say that there's a child who is an unaccompanied child and recently came to the United States and was recently reunified with their mother, who has been here for many years. She came 15 years ago. The child's 16. She left her child, her 1-year-old, with her mother to come to the United States to work and to provide for the family because there was really no resources. She has since married a US citizen and is now a lawful permanent resident based off of that relationship to her US citizen spouse now. But she's abusive. It's been so long since she has seen this child. It's very frustrating. The situation is very difficult. And she ends up using more than corporal punishment and really beats this young teenager who has come to be reunified with her. That young teenager can apply for VAWA protection. They might, it might be better for them to do special immigrant juvenile status if they're ultimately removed from the home, right? If they're the subject of a dependency and neglect based off of, because of that abuse, but they would also be eligible for VAWA protection. Okay. T visa for victims of human trafficking. So the T visa is a pathway to permanent residence for victims of trafficking and certain family members. So they must show that they were the victim of a severe form of sex or labor trafficking. So that it has to be commercial sex or labor services through force, fraud, or coercion. And when I think when people think of human trafficking and they think of sex trafficking, for example, it's usually this sort of organized prostitution ring or a massage parlor or girls being sold as part of by a pimp at parties or something like that. Commercial sex literally just means the exchange of sex for anything of value, right? And so it could be money, but it could also be a promise to refrain from calling immigration, right? That is something of value to that individual. So it could be that someone is eliciting sex in exchange for not calling immigration on an undocumented individual. Labor or services through force, fraud, or coercion can be, the sort of traditional, not traditional, but the concept of like working in a factory or working on a ranch somewhere without pay, and that through force. But it can also be, that's where drug trafficking falls. And we see a lot of teenagers who started their journey to the United States with an arrangement with a coyote or a guide. They pay a certain amount and they believe that they're going to be assisted into the United States. When they get to the border, and the story now changes, right? The agreement changes, and the individual that they thought was a coyote or a guide is actually a drug trafficker, and is now holding a gun to their head and says, if you don't bring drugs into this backpack of drugs into the United States, we're going to kill you. And so that is labor or services through force, fraud, or coercion. It can also be domestic services, right? A lot of situations that we see are where children are released into the custody of a family member, an aunt, an uncle, or what have you, believing that what they're coming to is, to be reunified with this aunt or uncle, and they'll get to go to school, and this aunt or uncle is like, please come, I'll protect you. And they get to the United States and they're not allowed to eat with the family. They are required to do all the cooking, all the cleaning, all the childcare of the younger children in the family. They're not actually allowed to go to school, or if they are allowed to go to school, that's all they're allowed to do. They can't leave the home. They can't contact their parents in home country, and they're being forced to do all of these tasks in the home without pay, and in order to pay this sort of nebulous debt of bringing them here, right? And no one really knows how much that debt is, and it might change depending on how many mistakes they make in the home. That is also a trafficking situation because it's labor or services through force, fraud, or coercion. They also must show that they're physically present in the US on account of such trafficking. So that makes it sound like the trafficker has to have brought them here from home country and been in control of them the whole time. All it really means is that there is some tie to the trafficking that means that they're in the United States. So for example, one of my clients was being trafficked in a nail salon, right? She was being forced to work in a nail salon. And yes, she was being paid, but a bunch of that money was being taken to pay off various debts that she didn't even realize she had. And she came on a visa. She came from an Asian country on a visa, on a visitor visa, and overstayed. So the trafficker didn't bring her from her country to the United States. She came of her own volition. But then when she came to the United States and was told, hey, yeah, get this job at our countryman owns this nail salon, like he'll give you a job. She's now in the United States and cannot leave that situation because of the trafficking situation. And then even if she were to escape, if she's accessing mental health services, if she's accessing law enforcement services, she's now physically present in the US to deal with the trafficking situation that she escaped from. They have to show that they complied with any reasonable request for assistance in the investigation or prosecution of trafficking, or were under the age of 18 at the time the trafficking occurred. So if you're an adult, you have to cooperate with law enforcement, or at least make a report to law enforcement. If you are under the age of 18, the law recognizes that it's very, very difficult to get a child to understand that it might be in their best interest to report their traffickers, right? It's difficult to get adults to understand that, but the law recognizes that it's very difficult for children. And then you have to show that they would suffer extreme hardship involving unusual and severe harm in the event of removal. So, in many situations, there's obviously evidence to show that it's not in their best interest to go back to their home country. But you also can argue that the reason that they became vulnerable to trafficking was that they were escaping what was happening in their home country. And so that would involve extreme hardship to return to a situation that would make them equally vulnerable. So the T visa, like the U visa, is a what's called a non-immigrant status on the outset. So it comes with permission to stay and to work for a period of time, but it does come with the right to then apply for a green card after 3 years of physical presence in the United States. And you can include family members on that petition. Any questions about T visa or trafficking?
None that are popping up.
Okay.
Yeah, I have one.
Okay, sounds like it's Bob.
This is Bob Hoyle, and I was curious, is there any reason to think that there's any kind of organized effort to send kids through and have them go through this process and thereby creating an easier path for the parents to follow them?
Well, so with respect to special immigrant juvenile status, so if a child gets status based on special immigrant juvenile status, they cannot petition for their parents. They are barred from petitioning for their parents, even if there's one parent who's not the offending parent, right? So let's say dad was the abusive party, and mom is the one who petitions for custody here in the United States, that she still cannot benefit from that petition. She cannot benefit from her child gaining lawful permanent residence. With respect to a U visa, yes, parents can be included on a child's petition as a victim of crime, but to be perfectly frank, it takes between 10 and 12 years to actually receive a U visa. And so I don't know that really would benefit someone to try and send a child in and to be victimized. And the crime has to have occurred in the United States. So, they would essentially have to assume that their child was going to become victim to a crime in the United States. Additionally, many people, when you talk to them, when I do consultations, they don't know about these forms of relief, right? They know about asylum. They know about coming to the United States and asking for protection based on, situations in their home country, but they're unaware of a T visa or a U visa or a special immigrant juvenile status. Many times with a U visa, we might be, talking to an individual, doing a consultation, really trying to find a form of relief. And then, we might even say, were you ever the victim of a crime? And they're like, oh no. And then, if you ask them, well, what's family life like? How was that? Oh, well, my husband, he gets very mad, or he drinks too much, and he occasionally will hit me. And the police came once, and and then you're like, wait a second, you were the victim of a crime. Like, that's a crime. It is a crime in the United States to hurt your family. And so we may be looking for police reports from 5 or 6 years ago, right? They just had no idea that they would be eligible for relief. I'm not going to say that there aren't people who don't come, that there aren't people who do come to the United States with a child knowing that they will be given better treatment at the border. Because there are some people who know that if you arrive with a child, you're not going to be summarily deported. You will be processed. But usually when I do consultations with them, if they're coming again, it's because the situation in their home country means that it's worth trying again. It's worth being held in a detention facility for months in order to have a chance at being protected from violence in home country. Did that answer your question?
Yes, thank you.
Mm-hmm. Any other questions about human trafficking or T visa?
None that are popping up.
Okay.
How are you doing? Do you need to take a break?
I just might occasionally take a sip of my coffee because my mouth is getting dry, but we can also take a break if people would like a break. I'm happy to take a break.
I'll follow your lead if you want to push through, but I just wanted to see if you were doing
I'm
okay.
happy to push through.
Okay.
So
we shall.
Okay, so adjustment of status is also a way for people to get to apply for status in the United States. And this is less victim-based and more that that family petition I was talking about. So this is sort of the precursor to the VAWA conversation, which probably I should have put that slide before the VAWA slide, but hey, hindsight is is 2020. Where someone has status in the United States, they may be able to apply for a family member or based on an employment relationship. In order to adjust their status to permanent residency or to a green card, there must be a visa immediately available. And this is why, you know, I talked about a wait list for special immigrant juvenile status, is because there isn't a visa immediately available to a child who's had their petition approved. The applicant must have entered the United States lawfully, so they can't have just crossed the border and entered, or they have to prove that there was an immigrant petition filed for them on or before April 30th of 2001. And this is a concession in the law made to people pre-2001, where if there was a petition filed before 2001, they can now use that previous petition to adjust status, even if they entered unlawfully. The applicant must be admissible to the United States or qualify for a waiver of any inadmissibility grounds. So you must be, in order to be admissible, you generally have to have no immigration violations, certainly not have any serious criminal violations. There are also health grounds of inadmissibility. So certain communicable diseases make you inadmissible, TB being one of them. And so you must pass a medical exam in order to enter the United States or adjust to green card status. So, you know, this can be a great form of relief for individuals, but it is also very difficult, right? Because of the rules about admissibility. Additionally, family petitions, depending on the category or the country that your family member is coming from, can take a really long time to have a visa immediately available. For example, if you had a family member in Mexico who's being threatened by cartels, and they call you up and they say, oh, please get me status in the United States. You know, I have to escape this cartel violence. A US citizen brother would say to their sibling, okay, but you have to wait anywhere between 22 and 25 years. So this is why people, you know, who might normally have a lawful way of adjusting their status or coming to the United States might present themselves at the border, which is also lawful, but might present themselves at the border to ask for asylum because they would have to wait 25 years in order to do so through their US citizen family member. For married couples involving a US citizen, obviously the time, the adjudication period is a lot lower, but for more distant relationships, the time period gets longer and longer for places like Mexico, China, the Philippines, India. As I discussed previously, the VAWA adjustment is for victims of domestic violence, and that allows the victim to stand in the shoes of the abusive partner and petition for herself. So that's, you know, it's the same concept as this family petition or adjustment of status. It just allows the victim to be the one who petitions. Okay, that's adjustment of status. And then asylum. So, you know, many of the children who are coming, who are at the border, and many of the people who are being processed through the migrant protection protocols or are presenting themselves at the border are asking for asylum. And asylum is a form of immigration relief available to those who are unable or unwilling to return to their home country because of past persecution or well-founded fear of future persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Typically, the applicant must apply within 1 year of entering the United States. There are exceptions for unaccompanied children. So if the child is an unaccompanied child, the 1 year filing deadline does not apply. There's also exceptions for changed circumstances. So someone who might have come as an economic migrant years ago, may now have a fear of return because of some new persecution occurring in their home country, be it a change in government that means that there's now a new religious authority in charge, or violence against certain races within their home country, that if a new situation has arisen that would amount to a changed circumstance, the 1-year filing deadline does not apply. And so, as I say on this slide, many people from Central America are currently fleeing to the US to seek asylum. So they're fleeing gang violence, they're fleeing violence that their governments are unable to control, right? They cannot seek protection in their home country. Many women are seeking protection from domestic violence, which would fall under the category of membership in a particular social group. A social group is a group of individuals who have similar characteristics that they are unable or unwilling to change. So they have to be characteristics that are inherent to them. So I am a woman, right? And so I shouldn't be forced to change the fact that I'm a woman, or I shouldn't be treated differently because I am a woman. And the domestic violence argument is that, in many of these Northern Triangle countries, women do not receive the same level of protection as men. And so they should be granted asylum in the United States. So that's asylum. I could do a whole training on asylum, but I think many of the children that you will encounter or work with, asylum will not be their strongest form of relief. We would probably go for special immigrant juvenile status or U visa or T visa relief before we would really proceed on asylum. So that's the end of all of my, straight information. I'm happy to open it up to general questions, questions about immigration. Can't guarantee that I'll have the answer, but I can certainly, I certainly have time. So.
And I will ask that the volunteers jot down your information, but this information will be available through me, through your SPC. Just reach out to one of us and we can get that information to you. I think our policy has been, in general, I'm not answering any questions, I'm deferring to you guys because things are changing so quickly. Deanna wants to know what is happening at the border right now.
What's happening at the border, right? Okay, so we do still have COVID protocols, right? So we're not, generally as a nation, we're not allowing those who enter unlawfully to stay in the United States because of COVID protocols. The exception being unaccompanied children. So if unaccompanied children are apprehended having tried to cross without presenting themselves at a point of entry, they will be allowed in under, and that was always supposed to be the rule. The rule was always supposed to be to exclude unaccompanied children. However, under the previous administration, unaccompanied children were being deported under the COVID executive health order. Under the Trump administration, there was what was called MPP, which was essentially those who presented themselves and asked for asylum were being processed initially and then returned to Mexico under an agreement with Mexico that they were going to allow asylum seekers to stay in Mexico. What that created was essentially border towns full of people who were just escaping violence and were essentially put in very dangerous situations by virtue of us not allowing them to come in and fight their case here. The current administration is doing away with MPP and is saying that that's no longer going to be our protocol and is allowing those who were placed in MPP to process and come into the United States. They have to present themselves at a point of entry. There are very specific points of entry that they can do that at, and that they will be processed will follow COVID protocols and then be placed in removal proceedings in whatever state that they are released to. Usually it's a state where they have friends or family members. So that's essentially what's happening at the border. Children, I think the issue with the unaccompanied children is that there just are not enough facilities open right now. There was such a drop in unaccompanied children being allowed to come into the United States that a lot of the shelters that are run by the Office of Refugee Resettlement shut down or, reduced capacity. And now they're having to ramp back up. And I'm not sure that there was an awareness on just how many children were waiting in Mexico or are still coming to the United States to escape the situation in their home country. So that's basically what's happening at the border at the moment.
Another question here. Under asylum, is the social group a broad category? For example, LGBTQ, pacifists, etc.
Yes. So it can't be so broad as to not really be kind of specific, but which I know that just is an infuriating statement, but LGBTQ is a very strong social group. Someone who is a pacifist or someone who is anti-gang, for example, would fall under two categories, right? I would argue that they're seeking asylum based on political opinion, right? Because it's their political opinion that gangs should not run the country. But I would also argue that they are a particular social group in that they are, a group of people. It could just be that they are religious and the church teaches that violence is not the answer, right? That is a social group and it's identifiable because in many cases in the Northern Triangle, it is the churches that are taking a stance against the gangs and protecting children. We've made arguments that youth group members, right, are a social group because youth groups are often put in place to kind of try and protect young people from being recruited into the gangs. And so it's a social group that's identified as being anti-gang, which is the de facto government, which makes them anti-government. There's a lot of leaps there, but that's essentially the argument that you're going to make. Hopefully that answered the question.
Yeah, thank you. Here's another one. If I understand correctly, it would be difficult for an adult to enter the U.S. for financial poverty reasons alone. For example, no asylum claim, abuse, etc. Is that correct?
Absolutely correct. So if someone is either caught or has presented themselves at the border, an adult, in order to be processed and allowed into the United States, would have to pass what's called a credible fear interview. And that interview basically is to assess whether or not there is a likelihood that they could prevail on an asylum claim. So they would have to essentially present a story that would fit into the arguments made, the arguments I just talked about with respect to asylum. They would have to show that they were being persecuted. They don't have to present their whole case, right? This isn't putting on the full trial or even having the sophisticated legal arguments that they would require in order to actually win the case. But they would just have to show that there was some persecution, that there is something that is a realistic reason for fear of returning to their home country. They can't just say, I'm just poor, or I don't have any resources. Unfortunately, they are just going to be immediately deported.
Thank you. Do all 50 states take immigrants equally, or does each state have their own immigration policies when it comes to unaccompanied children with no family or friends?
So there are, certain states can agree to have refugees released to their states. So there are processes there in terms of individuals who have been deemed to be refugees. And the distinction between refugees and asylees is generally a refugee is designated a refugee in their home country before coming to the United States. An asylee is seeking asylum in the United States. So it doesn't necessarily have that designation when they come. Refugees can then be released into programs that support refugees within the states, and the states have control over how much resources they allocate to those individuals. When it comes to unaccompanied alien children, what's going to be determinative in terms of how many kids are released into certain states is not entirely controlled by the state. So obviously it's controlled by how many people just live in that state and how popular that state is for a certain immigrant population, right? The state doesn't control whether or not an individual can sponsor a child coming to the United States. What does get controlled by the state is if they have a program called the Unaccompanied Refugee Minors Program, and that's a division. It's often within the existing foster care system, and not all states have it. So it's a way for a child who has absolutely no sponsor, right? No one comes forward for the child, or no one viable comes forward for the child. And they're just sitting in this shelter for a year or more. The Unaccompanied Refugee Minors Program is a way for that child to be released into the foster care system of the state. And that's where the states can control how many children come in. So it's dependent on how many slots there are in their, what their capacity is to process a child through the foster care system.
Great. Well, I think that wraps it up as far as questions.
Wow. I guess I was clear.
You were.
I didn't talk too fast or use too many big words, or my big thing is acronyms. I like default to the acronyms, and then people are like, what are you talking about? I'm like, oh, right. Sorry.
Yeah, I think we all do that, right?
Yeah. But again, I think the main purpose of the training is to try to make sure that people know who we are, know the services that we provide, and reinforce the fact that we want to hear from people. We want to hear from kids. We want to do these consultations. We want to be able to help people assess whether or not a child might be eligible for relief. And you all come in contact with kids in ways we don't, right? We have to wait until someone refers them to us, or we see them in court. We do community presentations and stuff when COVID's not an issue, but we really, really appreciate it when professionals kind of refer a kid to us. So if you have any doubt, even if you were not sure whether your kid's undocumented, if you think that they could benefit from an assessment with us, please contact us.
And if I remember correctly, all your services are free, correct?
Absolutely free. Yeah. Mm-hmm. The only things that people would end up having to pay for if they don't qualify for a fee waiver would be government application fees, because we can't pay for those.
And it's possible through CASA, we might be able to help them out. Possible. Great. Well, Emily, thank you so much. I will definitely direct everybody to email or contact you for further questions.
Yeah.
But this has been really informative, and it's a topic that is changing as we speak. So it's really good to have you. I think having you every year is just going to be a good idea.
Well, and things are changing in that this administration has essentially put a freeze on any new actions to be taken while they assess what policies have been put in place and what procedures need to change or what policies need to change. And so, it's always worth reaching out to us, because we try to stay on top of whatever the newest development is in terms of policy change.
Okay. Well, thank you, you all. Expect to see this if you're seeing this live. Right now, I will put your hours into Optima. If you're seeing this as a recording, it's going to be up to you to put your hours in, because I'll have no idea if you viewed it. So, yeah, have a good day, everybody. And reach out if you have any further questions. But Emily, thank you so much. This was
You're
really,
welcome.
really good. Thank you.
Thank you.